Hello students, welcome to EPG Pathshala. I am Dr. Mandeep from JNTU Amritsar. Today we are going to talk on the module the Competition Act 2002 from the paper Business Environment. After completing this module, you will be able to understand the meaning of this Competition Act, the definitions given in the Act, the features of the Competition Act, and the concept of Competition Commission of India along with its functions and powers. With the expansion of business in globe, the need was felt to provide an act for the economic development of the country, for the establishment of the commission to prevent practices having adverse effect on competition, to promote and sustain competition in the market, to protect the interest of the consumers, and to ensure the freedom of trade carried on by participating in the market. Our government, that is Government of India, appointed a high-level committee on competition policy and competition law to advise a modern competitive law. That for the purpose of this in 1969. The committee presented its competition policy report to the government in May 2000. In November 2000, the competition law was drafted and presented to the government, and after some discussion and consultation with the interested parties, the new law, namely the Competition Act 2002, was passed in India. This act may be called the Competition Act 2002, which extends to whole of India except the state of Jammu and Kashmir. It shall come into force on such date as the central government may by notification in the official gazette appoint. There are various definitions relating to the various concepts given in this act. It includes so many, and all of them are given under section 2 of the act. For example, acquisition. Section 2A explains the meaning of acquisition, which means directly or indirectly acquiring or agree to acquire shares, voting rights, or assets of the enterprise, and control over the management or control over assets of any enterprise. Next one is agreement. Section 2B defines agreement. It includes any arrangement whether or not such arrangement, understanding or concert formal in writing, or whether or not such arrangement, understanding or concern is intended to be enforceable by legal proceeding. Then comes term cartel. Defined under section 2C of the Act, it includes any association of producers, sellers or distributors, traders or service providers who by agreement by themselves limit, control or attempt to control the production, distribution, sale or price of the trade in goods or provisions of services. Another definition is chairperson according to section 2D. It means the chairperson of the Competition Commission of India appointed under section 1 of section 8. Then commission. As per section 2E, it means the Competition Commission of India established under section 7.1. Consumers according to section 2F includes only such purchaser or buyer who make purchases for their own consumption or to earn their livelihood. Then is Director General. As per section 2G, it means the Director General appointed under section 16.1 and also includes additional, joint or deputy or assistant Director Generals. Enterprise. As per section 2H, it means any person or department who is engaged in any activity relating to production, control of goods or articles, or provision of services of any kind, or in investment,
or in the business of acquiring, holding, underwriting, or dealing with shares, debentures, or other securities, whether such unit or subsidiary is located at the same place or at different places. Another term, that is goods. Section 2I. It means as defined in Sale of Goods Act 1930 and includes the product manufactured, processed, or mined, the debentures, shares, and stock after allotment in relation to goods supplied, goods imported into India. Next come the term member as per section 2J. It means a member of the commission appointed under section 8(1) of the Act. It includes even a chairperson. Notification. Section 2K. Notification means notification published in any official gazette. Next is the person as per section 2L. It includes any individual, any Hindu undivided family, a company, a firm, an association of persons, a corporation established under central, state, or government company, a body corporate incorporated under a law of foreign country, a cooperative society registered under any law, local authority, every artificial judicial person. Next comes the term practice. Section 2M. It includes any practice relating to carrying on of any trade by the person or enterprise. Prescribed as per section 2N. It means prescribed by the rules made under the Act by the central government. Next is price, section 2O. Every valuable consideration, whether direct or indirect or deferred, includes any consideration which relate to the sale of goods or any other good. Public financial institution, section 2P. Public financial institution is defined in section 4A, Companies Act 1956, and it also includes state, financial, industrial, or investment corporation. Regulation according to section 2Q. Regulation means regulation made by the Competition Commission of India. Relevant market, section 2R. The market which may be determined by the Commission with reference to relevant product market. Now, relevant geographical market, section 2S. Relevant geographic market is a market which consists of the area in which the conditions of competition for supply of goods or services are homogeneous and can be differentiated from the conditions prevailing in the neighboring areas. Next comes relevant product market, section 2T. It means a market comprising of all those products or services which are regarded as substitutable and interchangeable by the consumer. Service, section 2U. It means service of any description which is made available to the potential users and includes the provision of services in connection with the business of any industrial or commercial matters like banking, education, financing, insurance, transport, storage, energy, boarding, lodging, entertainment, construction, repair, and advertising. Shares, section 2V. It means share capital of the company carrying voting rights. It includes any security which includes the holder to receive shares with voting rights, stock except where the distinction between the stock and share is expressed or implied, Next is statutory authority, section 2W. It means any authority or board or corporation or council or institute or university or a body corporate established under any state, central or provisional act for the purpose of regulation of production or supply of goods or provision of any services. Next comes trade, section 2X. It means any trade or business or industry or profession or occupation which is relating to production, supply, distribution, storage, or control of goods and includes the provisions of any services. Turnover, section 2Y. It includes the value of goods and services. Now let's discuss features of Competition Act 2002. Competition Act 2002 has essentially four features. First is to prohibit anti-competitive agreements as per Section 3, prohibit the abuse of dominant position, Section 4, to regulate the combinations, Section 5 and Section 6, and last is competition advocacy, Section 49. First one is anti-competitive agreements. These are those agreements which can cause or likely to cause an appreciable adverse effect on competition, known as AAEC. Such agreement may be horizontal or vertical. Horizontal agreements are between the enterprises at the same stage of the production chain and is generally between two rivals for either fixing prices or for sharing market or for limiting production. These are presumed to be illegal. For example, cartels, bid rigging, collusive bidding and sharing of markets, etc. Then comes vertical agreements. These agreements are between the enterprises at different stages of production chain, like an arrangement between the manufacturer and the distributor. They are not presumed to be illegal. For example, tie-in arrangements, refusal to deal, exclusive supply or distribution agreements, resale price maintenance, etc. Bar from entering anti-competition agreement, according to Section 3, subsection 1 of the Act, it provides a prohibition on the following to enter into the agreement which causes or likely to cause an AAEC in India. That is an enterprise, association of persons, two associations of enterprises, and two associations of persons. If an agreement is entered between any of the above, it would be considered to be void under the Act. Section 3, subsection 2 of the Act states that even if the agreement has been entered into outside India, the CCI would have the powers to inquire into such an agreement if such agreement has an AAEC in India. Similarly, Section 3, subsection 3 of the Act states that an agreement entered into enterprise, association of person, two associations of enterprises, or two associations of persons for similar goods or services, which directly or indirectly determines sales or purchase price, limits or controls the production, supply, markets, or technical development, shares the market or source of products or services, directly or indirectly result in bid rigging or collusive bidding. Secondly, it shall be presumed to have an appreciable adverse effect on competition. Section 3, subsection 4 of the Act states that any agreement amongst the enterprise or persons at different stages in respect of production, supply, distribution, storage, sale, or price, including the tie-in agreement, an exclusive supply agreement, exclusive distribution agreement, refusal to deal, resale price maintenance shall be an agreement in contravention of the subsection 1 if such agreement causes or is likely to have an appreciable adverse effect on competition in India. Tie-in agreement. These are those agreements where the purchaser is required to buy some other goods. Example is when a gas distributor requires a customer to buy a stove, he wants to get connection of gas. Secondly, an exclusive supply agreement. That is any agreement which restricts any person to acquire any goods other than those of the seller. Then comes exclusive distribution agreement. Any agreement requiring the distributor not to sell goods from the manufacturer beyond the prescribed area. Then comes resale price maintenance, an agreement which refuses to deal with any product or service of similar nature for a particular period. Resale price maintenance, any agreement where it stipulates any condition not to sell the goods below the stipulated price. Second is abuse of dominance. A dominant position is defined as a position of strength enjoyed by an enterprise in the relevant market in India, which enables the enterprise to operate independently of competitive forces prevailing in the market, or it affects its customers or consumer in its favor. There is no mathematical or statistical formula to measure this dominance, but the following cases are regarded as an abuse of dominant position, like an enterprise directly or indirectly imposes unfair or discriminatory condition in the purchase or sale of goods, or the price in purchase or sale of goods or services. Division of enterprise enjoying dominant position. According to the section 28 of the Act, the competition commissions may order the division of the enterprise enjoying dominant position in order to ensure that such enterprise does not abuse its dominant position.
Regulation combination. It basically includes a merger and amalgamation or acquisition of shares, acquiring the control and voting rights of the pre-mandatory notification before the merger. The Commission must decide in 210 days is combination approved. The Commission can take suo motu action within 365 days after the combination. Section 6 of the Competition Act prohibits any person or enterprise from entering into agreement which causes an appreciable or adverse effect on competition within India, and if such combination is formed, that will be void. Section 6 subsection 2 of the Act states that any person who is entering into any agreement must inform to the prescribed authority within 30 days together with the fees as decided by the authority.
Fourth one is competition advocacy. Under section 49 of the Competition Act, central government or the state government may take advice from the CCI on the policy of the competition. The Commission will give his opinion to the government within 60 days for the formulation of policy. The role of the Commission will be advisory and will not be binding on the government. The Commission is empowered to take suitable measures for the firstly, promotion of competition advocacy, secondly, creating awareness about the competition and imparting training about the competition issues. Next comes the Objectives of Competition Act 2002. This is an act to provide for economic development of the country, for the establishment of a commission to prevent practices having adverse effect on competition, to promote and sustain competition in the market, to protect the interests of the consumers, and to ensure freedom of trade carried on by the participation in the market. Competition Commission of India, that is CCI, the central government under Section 7 has been empowered to establish a Competition Commission of India by the issue of notification. Competition Commission of India, that is CCI, is a body of the Government of India which is responsible for enforcing the Competition Act 2002 throughout India and to prevent activities that have an adverse effect on competition in India. It was established on 14th October 2003. Let's talk about the composition of this Competition Commission of India. According to Section 8 of the Act, Competition Commission of India consists of one chairman and 2 to 6 other members to be appointed by the central government. Section 8 subsection 2 provides that they shall be the persons of ability, integrity and standing, and who has the knowledge and such professional experience, and must have experience of not less than 15 years in international trade, economics, business, commerce, law, finance, accountancy, management, industry, finance, public affairs, or competition matters, including competition law and policy. The chairman as well as other members shall be the whole-time members. Now, the term of office of this chairman and other members, they shall hold the office for a term of 5 years and shall be eligible for reappointment even, provided that the chairperson or other member shall not hold office after attaining the age of 65 years. The senior-most member shall act as a chairman in the event of death or resignation of the chairman. If any vacancy is caused by the resignation or removal of the chairperson or any other member by death or otherwise, it shall be filled by the fresh appointment according to the provisions of the Section 8 and 9. As far as the resignation and removal or suspension of the chairperson or members is concerned, the Act states that the chairperson or any other member may by notice in writing under his hand addressed to the central government resign his office. The central government may remove the chairperson or any other member if the person is adjudged as an insolvent or he has engaged during his term of office in any other paid employment. Moreover, if he has been convicted of any offense, he has acquired such financial or other interest as is likely to affect prejudicially his function acting as a member, or he has become physically or mentally incapable of acting as a member. As far as the salary of the persons is concerned, the salary allowance and other terms and conditions of the service of the chairman and other members, including travel expenses, house rent allowances, conveyance allowances, and other medical facility, shall be as such prescribed by the authority. Appointment of Director General. Now, Director General is an important functionary under the Act. He is to assist the Commission in case of any inquiries and for performing such other functions as may be prescribed by the authority. Section 16, subsection 1 empowers the central government to appoint Director General and such number of additional deputy or assistant Director General or any other advisors and consultants. Now, what are the duties and functions of Competition Commission of India? The very important duty is to create
equal chance for all the producers. Moreover, to create awareness among the people, to assist common people by providing goods and services at reasonable and convenient prices, to protect the interest of the consumers, to eliminate the practices which are having adverse effect on competition, and to discourage any anti-competitive agreements.
Competition Commission of India has been entrusted with the following two basic functions, that is, administration and enforcement of competition law and competition policy to foster economic efficiency and consumer welfare. Second, involvement proactively in the government policy formulation to ensure that markets remain fair, free, open, flexible, and adaptable. Next is power to exempt. The central government is empowered to exempt from the application of this Act or any provision thereof, and for such period as it may specify, any class of enterprise if such exemption is necessary in the interest of the security of the state or public interest. Secondly, any practice or agreement arising out of and in accordance with any obligation assumed by India under any agreement with any other country or countries. Any enterprise which performs a sovereign function on behalf of the central government or the state government, provided that in case an enterprise is engaged in any activity, including the activity related to the sovereign functions of the government, the central government may grant exemptions only in respect of the activity related to the sovereign function.
So students, let's now summarize what we have learned in this module. The economic liberalization increased the need for and relevance of competition policy and law because while the liberalization unleashes competitive forces in the absence of the safeguards, this may also provide scope for unfair competition, like powerful competitors crushing the small firms through unfair competition. Thus, Competition Act 2002 is a great step to combat the competition in the country. Thank you very much.